Okay, everyone should be able to see that. Thanks for having us, everybody. My name's Ben Moody. I'm the Housing Programs Managing Attorney at the Clark County Volunteer Lawyers Program. We've put together a little PowerPoint presentation. This is a kind of informational, general advice presentation, the sort of thing we do for various organizations and groups in and around Clark County. We also sometimes do these tailored towards specific audiences if they have specific needs, or we can cover other topics more in depth. So whether you're here for the informational information or to see kind of an example of what sort of presentations we might give, will hopefully shed some light on things. So we have our little agenda here, but we're just going to keep on moving. So the Clark County Volunteer Lawyers Program, we are a pro bono legal services organization. We provide free legal services to low-income members of our community. That can be full representation, meaning actually an attorney assigned to take your case, to go to court, to help you defend or sue someone, depending on the subject. And that is full representation is often through our staffed programs, being survivor support and domestic violence, eviction defense if someone has had an eviction case filed against them, or in some cases in our housing justice project, that is housing disputes and issues that have not yet gone to an eviction case or are not headed that direction. There's some limited availability. We're hoping to expand that program this year. But for now, that program has a lot of also advice clinics, more than we have full representation, but there is some full rep available. We do offer advice clinics and more limited legal services, oftentimes with our kind of cadre of volunteer attorneys in a number of other programs, including one we call Children First, our early parenthood program, employment law, general civil law, guardianship, and immigration. And of course, as I said, our housing justice project. So the first main section, we're talking about housing. I forgot to introduce Rob Sellers, our one of our staff attorneys in our eviction defense program.
Hello, I'm Robert Sellers, and I will talk to you about sort of the tenant responsibilities, rights and responsibilities. The first big rule is always pay the rent. There's a lot of people believe that if they have some sort of dispute with the landlord, they can withhold rent as a way or method to force the landlord to resolve the dispute. This is not correct. Withholding rent, not paying the landlord for any reason, will give the landlord generally a reason to evict you, regardless of anything else that's going on. And rent isn't just rent, it's all reoccurring monthly charges for use and occupancy of the premises. So that's utilities, that's parking spaces, that's garage spaces, that's those kind of things. Keep the home clean inside and out. Let's just sort of follow the rules of the lease, and don't be a nuisance to the neighbors, kind of thing. And permanent changes to the property need to be something that the landlord in writing agrees to ahead of time. So you can't like put in a pool or move a wall or something like that without the landlord telling you that you can do that. The leases cover generally the people that are on the lease. So almost all leases that we see have a term saying along the lines of, if somebody's going to stay for 10 or more days, you know, you have to notify the landlord and get permission. So it's, if you violate those terms and people come in and stay longer or move in, that can be a basis for eviction. And that is one of the more common reasons we end up defending evictions, um, almost after non-payment. Um, the do not disturb the neighbors with noise and arguments, that goes along with, keeping the home clean inside and out. You can't, everybody has a right to the quiet enjoyment of their premises. And if you are, if you violate somebody else's right to quiet enjoyment, it gives the landlord a reason to evict you. And the quiet enjoyment basis is sort of a very large catch-all, that means that there's a whole lot of other reasons, but you can basically pack it into that, um, for why you run into issues. So you need to double check and ask for help if you're having problems with those things. Due dates are very important. Due dates in leases and due dates, on notices set and establish legal rights for action. So your rent is due generally on the first day of the month. If you pay later than the 5th, they can assess you a late fee if that's part of the lease. But for most leases, between the first day of the month and the 5th day of the month, so days 2, 3, 4, and 5, if you have not paid, you are already late on your rent, and a landlord can issue a pay or vacate notice. They don't have to wait for that 5th day when they can charge a late fee before issuing a pay or vacate notice. But the other problem is late fees can build up. Some landlords will charge daily late fees or $150 for a late fee. The most common late fee amount that we'll see is $75. If people that are late every month, that can really get expensive. And even though your landlord can't evict you for late fees, you still technically owe that money. They can report you to credit and try and harangue you to get that collection. And along with, like I was saying with the due dates, a single day late on any notice or date is going to be a violation of that notice or date. So if it's a 14-day notice to pay or vacate and you try and pay on the 15th, that's a violation, and they can already be in the process of evicting you. If it's a 10-day notice to make a repair because something, say, that would be a tenant's responsibility that they broke or rule violation that they can correct. You make the correction on day 11, then they can evict you. The rules, when you have a dispute with your landlord, you can negotiate resolutions, but it's important that the communications happen in writing. There are so many times that we have conversations with our clients where they said, well, they told me this, we agreed to this, and we ask, well, how can we prove that? Because they're saying that did not happen right now. And then our clients said, no, we talked over the phone or we talked in person. I always advise my clients when talking to landlords in person or over the phone to send a text or email to confirm the details of the conversation so they get that record and they get it in writing. Any agreement from a negotiation is going to be enforced by a court very strictly. When I talk to my clients to say about repayment agreements, I say that those have to be that being 1 penny short or 1 second late is the same thing as bringing nothing to the table at all. And here's some examples of different rent agreements. So you can get an agreement to pay off a rental debt by a certain time, an agreement to repair something that maybe goes beyond a 10-day notice to fix or vacate. And you can get an agreement for to adjust a term restricting pets or add somebody to your lease or allow somebody to stay for a certain amount of time. And now I will hand this over to Ben since he's got some good tips for renters.
Yeah, thank you, Rob. And those things where we talk about making those agreements, those are a good way to try to resolve an issue you have with a landlord before it escalates. So we do recommend talk to your landlord, try to resolve an issue, figure out a time to do a repayment plan or remove somebody. But as my top tip number one, will repeat from what Rob said, do everything in writing. These are some of the top tips I tell all my clients, both ones facing eviction and ones just having a dispute, whether with a neighbor or with a landlord or any sort of housing issue. These are things that seem to come up most often. Number one, do everything in writing. This is no matter who your landlord is. I don't care if it's your sister. Do things in writing and always keep a copy. This is especially if you need repairs or if you're giving notice to the landlord that they've done something wrong, like they're coming into your unit without permission, you need to give them a written notice. If you need a repair done, that's a written notice. If you're making a deal, give a notice in writing. That can be a text message, it can be a letter, it can be written on a cocktail napkin. My favorite thing is email because it has dates on it. You can see who it was sent to, makes a fantastic record, and it's really hard to lose. People who do text messaging, if they lose that phone and they don't have a way to recover those text messages, if their service doesn't provide that for them, they might have lost all their evidence that they had a deal, that they had given a notice. And if they want to enforce rules against the landlord because the landlord never fixed the heat or they had made a repayment plan arrangement and they don't have the evidence of it, they might not be able to enforce that. So always keep a copy, do it in writing. And if you have a conversation with a landlord that's on the phone or in person, follow up with a letter or an email that says, hey, here's what we just talked about. Do I have all those details correct? And that way you're kind of creating that written record, even if it's after the fact. Top tip number two, pay the rent first and pay it on time. Rob talked a lot about this. This has a couple of meanings. Don't withhold rent if your landlord does something wrong. The law almost never lets you do that, and it is the fastest path to an eviction case if you withhold your rent. The best way to do it is to pay the rent and then have a dispute. The landlord hasn't fixed something, I'm going to pay the rent, and then I'm going to have a dispute. I'm going to give them a written notice and talk to the CCVLP about what my options are for enforcing my rights. The other thing is pay the rent first before other expenses out of your budget. Rent is the hardest thing to get help with right now. There's very limited resources for rent assistance. And if you've got a budget between your food budget and your utilities and your insurance and all that stuff, there's a lot more help available for food and clothing and utilities than there is for rent. But also don't be afraid just to reach out to those organizations to make sure if you qualify for EBT or other food benefits or some sort of discounted rate on your utilities. Make sure you're taking advantage of those before you stop paying your rent. Because as soon as you stop paying your rent, you're going to be in trouble facing an eviction, and that can have a lot of knock-on consequences, making it harder and harder to get stable housing. Top tip number 3, take pictures of everything and keep copies of it. This is a lot like rule number 1, actually. This is making a record for yourself. Take pictures of things when you move in, take pictures of everything when you move out, and if there's a problem, take a picture of it, keep a copy, not just on your phone, but in at least 2 places. Once again, the landlord has a lot of duties that we're going to get to some of those in a bit. But if you don't have documentation to prove what the landlord has or hasn't done, or what they're obligated to do, you might not be able to enforce that. If you don't have pictures and records of what the condition of your home was when you moved in, and you move out, the landlord may try to charge you for things that they're not allowed to do, but you might not have a record to easily prove that that carpet was old and gross when you moved in, and now they want you to pay thousands of dollars to replace it. So there's ways to defend yourself if you don't have those photos, but it makes it a lot harder. It's much easier to protect yourself if you make a record, take photos, keep copies. Top tip number 4, we've touched on this as well. Read your lease. The law provides a lot of rules and protections, but your lease provides a ton of details and rules in every rental situation. So read your lease, pay attention to the dates that are in there, the rules for behavior, the rules for who can and can't live there, how long your guests can stay, what the quiet hours are. There's a lot of stuff that you might get in trouble for if you haven't read the lease. But there's also a lot of things your landlord might do or not do that the lease has a rule about. How much can they charge you? Are they allowed to charge a fee for posting a notice to your door? Well, check your lease. Did you agree to that? Is that in writing? If not, they can't do it. And if they are, do they charge the correct amount? Are you following all the rules? Are you reporting, water damage that you need to as soon as you see it in order to protect yourself from the landlord saying that's your liability? Check what's in your lease. Be aware of that stuff. Rule number 5, please don't use money orders to pay your rent. Also, don't use cash. It's the only thing worse than a money order. But money orders cause a lot of problems. The landlord has to accept a money order or a cashier's check for any rent you owe. They can't make you use an online portal. They have to always accept a money order or a cashier's check. The problem with a money order is that if there's a problem with it, if it gets lost, if you need a refund of it for some reason, it takes at least a month. And if you need to do an investigation to see where it's at, has it been cashed, it might take longer. And you also have to have kept all your receipts and stubs for those money orders, because if those get lost, you're probably not going to be able to get a refund or track it down. We see clients all the time that paid with a money order, didn't get a receipt, and now we don't have a record of was their rent really paid. So really try to avoid using it. Cashier's checks are a much better option. Most of the time, though, you can just pay with a personal check. If you are banked, paying with a personal check, you can always do so long as you haven't bounced a check to your landlord in the last 9 months. If you need to use a money order because you don't have a bank or can't get a cashier's check or use an online form of payment, get a receipt. Landlord has to give you a receipt when you ask for it. So get a receipt. If they don't have a receipt readily available, take pictures of yourself handing over those money orders, or pictures of them with you standing in front of their door or their drop box and then putting them in there. Make your record to protect yourself, but really just avoid money orders. There's a secret, number 6, there's no law against your landlord being a jerk. If they're doing something for a discriminatory reason, it can be against the law. But if they just don't like you and are going to make your life difficult, that's not against the law. If they don't want to continue renting to you because you had late fees, even though they can't evict you for late fees, they'll find a reason not to continue renting to you because they don't like you. So be aware of that. There are a lot of things landlords do that are illegal, but they're actually, weirdly, for apartment rentals in Washington, not required to be fair, so long as they follow the law. And go back to Rob here, talk about common notices we see from landlords.
Yeah, so landlords have to take action generally through a series of legally prescribed notices. The most important notice or notices that they have to give is the 14-day or 30-day notice to pay or vacate. We, doing eviction defense, probably 9 out of every 10 evictions that we see are about pay or vacate notices. Um, like I said before, rent includes all reoccurring charges. The other thing about pay or vacate notices, and once you get into a eviction proceeding for non-payment, is that partial payment does not stop the eviction process. On top of that, your landlord's likely, if you get into an eviction process, to start rejecting rental payments unless it's a payment in full for a non-payment of rent eviction. Because partial payments don't stop the eviction, that can actually work to your benefit because then you can use that money to move if you have to. But ultimately, the 14-day pay or vacate notice is the most important. And we have an example of the 14-day or 30-day pay or vacate notice here. And the difference between a 14-day pay or vacate notice and a 30-day pay or vacate notice is depending upon some issues that are usually not visible to the tenant, whether or not there's some federal money backing the landlord, they can be required to make a 40-day pay or vacate or a 30-day pay or vacate. If you have a Section 8 voucher, the landlord is always required to do a 30-day pay or vacate rather than a 14-day pay or vacate if you fall behind in your rent. But the pay or vacate notice has to show, it's got to be dated so that you know when it's to count from. It has to be, it's got to show the amounts so that you know how much to pay. And it's got to give you some information on, how to pay and all that kind of stuff. The at the on the on our example pay or vacate notice right here, you'll notice that there is towards the bottom of the page on the left a phone number for the clear hotline outside of King County. So that is a phone number that you can call to get connected with us here at the Clark County Volunteer Lawyers Program, primarily with the Northwest Justice Project, which is one of our colleague organizations that does eviction defense and advises for people facing eviction and problems with their landlord. The next, another really important notice is the 10-day notice to comply or vacate. This is a notice that's claiming that you've violated a rule and the rule is fixable. So you then have 10 days to come within compliance of the rule. Now, this can be a little weird or wonky how this works with say it's a noise complaint. Say you're too loud outside of the period, the quiet period set in the allegation is that you're too loud outside the quiet period. What it ends up being is if it's something like that, if it's not like you have to repair this damage to the property type fix-it notice, then they have 60 days following the notice where they can claim that you continued the behavior and seek an eviction. But if you go 60 days from the end of a pay or vacate notice without repeating that behavior, then that is considered that you have complied. That being said, if you accumulate 4 or more 10-day comply notices in a year, they can evict you whether or not you have been complying with those notices if they were validly issued. All right.
As an example on that sort of notice, if it is you are keeping trash out on your balcony, then that's not allowed. You have 10 days to get it cleaned up, but if you put more trash out there in the next 60 days, they can still say you didn't comply with this notice. So that's something to watch out for.
Yeah. And as we've been hammering with the time periods, if we go to how to respond to a notice, these notices are the start of the process for the landlord to assert their rights to evict you. And it's important that the timelines in the notices be followed strictly. After a 14-day notice to pay or vacate, on day 15, you are in violation of the notice if you have not paid or vacated. And they can now start legal proceedings to force an eviction. If you've received a 10-day violation of the lease notice and you haven't complied with that on the 11th day or during that 60-day window for like a noise violation, then you are in violation of that notice, and they can go with further legal proceedings to evict you. And it's important, once again, communicate with your landlord about these notices if you receive them, and do that communication in writing. I paid, here's the proof. I fixed it, here's the proof. Emails, pictures. The first thing that they teach us in law school is if we don't have a record, it didn't happen. If an eviction lawsuit is filed, you're going to receive a packet of paper that we call the summons and complaint. It has required to include 2 documents, an eviction summons and a complaint for unlawful detainer. At that point, you can reach out to us at the CCVLP. We have the phone number right here, or you can email us, and we can start representing you as your attorneys if you qualify for our services. And we're public defenders. The government will pay our fees. You won't have to worry about that, assuming you qualify. Also down here, we have the eviction defense screening line, which will connect you either with one of our colleague organizations or with us, most likely one of our colleague organizations. But the moment you get the summons and complaint, that's what triggers your right to an attorney. And the next slide is an example of an eviction summons. So you have, this is clearly court paperwork. At the top, in the Superior Court of the state of Washington for the County of Clark, legal name of your landlord, name of the people being sued for an eviction, place for the case number, title of the document. And it's going to have the contact information for us. It's going to have the eviction defense screening line, so you can call and screen for an attorney. It's going to have the contact information for your landlord's attorney, and with their address, their phone number, and how to contact us, how to contact them. And then it's going to have, who the law firm is and that kind of information. So once you receive this is when you can start reaching out directly to attorneys and get help. We can represent you if you qualify for services. It will not cost you anything. And now I'm going to hand back to Ben, who's going to go over the responsibilities of the landlord.
Thank you, Rob. Yeah, if you get an eviction summons, that is your key, that there is now a timeline. You also want to watch out for a second piece of paper we don't have an example of here, called an order to show cause. That is actually the paper that sets your court date. It's usually in the same packet with the summons and complaint. The complaint tells you what the lawsuit is about, and it's going to be the longest part. The summons tells you that you need to respond to the lawsuit. Show cause order sets your court date. Might be the last page. It might come the next day and be taped to your door or in the mail. But
Yep.
look for that, because that tells you when to go to court.
And ironically, or interestingly, the example paperwork that Ben chose here for this document is from the law firm that almost always sends the eviction summons and complaint separately from the show cause order, which sets the court date.
Yeah. But once you have this, you know to be on the lookout for something that says a court date. So look through that whole packet, and then if you don't see it, watch for it to get delivered or mailed to you. Okay, I'm going to talk a bit about landlord responsibilities. There's a lot of protections under the law of things the landlord is required to do. We're not going to get into all of them, but we're going to talk about some of the main ones. So the first thing, these are what we call habitability issues. A landlord needs to provide housing that is free of defects that are imminently hazardous to your life or health. That means they have to have working heat, hot and cold running water. The electricity has to work and not be an obvious fire hazard. It needs to have secure locks. It can't let the weather in so the wind and rain gets through, or be structurally unsound to the point where it's not safe. A landlord has to keep shared, or what's called common areas, clean and safe. They can't allow hazards in there. If a tenant is putting stuff out there, that might be the tenant violating their lease. But if it's not caused by a tenant, the landlord has to take care of it. And the landlord has to do repairs for damages that weren't caused by the tenant. Now, the landlord always has that duty, but if the tenant hasn't given a written notice, the tenant has no way to enforce that against the landlord. They can't get the court to say, hey, landlord, you can't keep charging this rent if you don't do a repair, or put in an order from the court requiring the landlord to immediately do the repair, unless you've given the written notice. One thing that's also important to note as a tenant, if you're behind on your lease, you also lose most of your protections and remedies under the law, where even if you've given that written notice, if you're behind on your rent, the landlord might not actually have to do the repair because there's no consequences for them. Other things, I talked about this. Landlord has to give a receipt when you pay your rent if you ask for it, and always ask for it or make one for yourself. If a landlord is changing the rules, they need to give you notice ahead of time of at least 1 month that they're changing the rules. It might be longer depending on if they're changing a rule like rent, or if you're in the middle of a lease and the rules are locked in. Another thing, if a landlord is ending your tenancy, they need to give you a written notice. This isn't the same as court paperwork where they have to try to have someone personally hand it to you and do all this process. They have to have someone knock on your door, but if no one answers, they might just tape it to the door and stick a copy in the mail and call it good. But they do have to give you a written notice ahead of time. Another thing a landlord has to do, and this applies more to apartments rather than what we call single family residences, which are houses or mobile homes, is that the landlord has to control pest issues. If you're renting a whole house, it's your responsibility to control pest issues after you move in. The landlord has to give it to you in a condition where pests are under control, but after that, you have to take care of it. If it's an apartment, the landlord has to handle pest issues unless you caused it by having giant piles of trash or leave food out all the time. In that case, the landlord can blame you for it. So again, keeping the place clean is one of your responsibilities. But if something like this comes up, document it. Pictures, written notice, all of that. And that triggers the landlord's responsibility to fix things. a landlord hasn't been fixing things and you've kept up with your rent and you've given them their written notice, you can ask the court to give you a discount on your rent, to tell the landlord they have to refund rent you've overpaid because your place isn't worth as much as it's supposed to be worth because they didn't fix the heat or take care of the roach problem. But you've got to protect yourself by making your record, by giving the landlord written notice. There are a lot more rules for landlords that might be outlined in your lease. They might have to give you more time on a notice to comply or to pay your rent because the lease says so. There might be other duties they have. It's important to know that and read your lease. You can also read the law. It's a bit wordy, but there's a lot of guides online you can also find that can tell you about what your landlord's duties are. And if you're not sure, or you want to know if a landlord has to do something, contact us at the Volunteer Lawyers Program. We're happy to set up an appointment for you to talk to an attorney. Remember that your landlord is not afraid to use court to get what they want, to try to evict you. But we want you to have the same opportunity. If your landlord is not treating you right, if they're breaking the law, we want you to have the opportunity to protect yourself, to enforce the law. Excuse me just a second. Remember that all of our services are free if you qualify as low income or through some other benefit programs. We never charge for anything we do. We provide legal services for non-housing issues. We provide full representation if you're getting evicted. And we provide, at the very least, advice clinics for other issues like non-eviction housing issues. But sometimes we can also provide full attorneys for that. I've got some numbers and email addresses on screen for how to contact us. If you've got a non-eviction housing issue, whether with your landlord or a neighbor or a general question, please call us at that top number ending in 4007. If you've received an eviction lawsuit paperwork from your landlord, there's a second number on there ending in 7872 and a different phone number. You can call us there or at the number that's on your eviction summons. For other issues, we had that list at the beginning. Please call us at 695-5313 so we can see if we can get you into one of our other clinics. All right, with that, that's the end of our prepared presentation.